Welcome. My name is Ashley Jones, and I'm the Vice President of Cherif Medawar Real Estate Investing. I want to thank everybody for coming tonight from all around the country. I really, really appreciate it. We have a variety of professionals and investors on this webinar, and I just know you guys are going to be happy of the time you're investing with us. So by the end of the session, you're going to have priceless strategies coming direct from our trusted attorney. So for the next 50 minutes, I'd like you to participate with Bob Bluhm. Bob Bluhm has been an attorney for nearly 30 years and is one of the nation's leading asset protection strategists. Bob spent several years as a trial attorney and has presented in court and represented a number of Fortune 500 companies, as well as smaller privately held businesses and, of course, real estate investors. Having seen firsthand how devastating a lawsuit can be, Bob turned his attention to protecting people and their businesses from the threat of litigation. As a speaker, Bob has shared the stage with notable political figures such as President Clinton, President Bush, Margaret Thatcher, Mikhail Gorbachev, and even financial figures such as Donald Trump, Jim Cramer, David Bach, Susie Orman, Robert Kiyosaki, and even Cherif Medawar. He is the author of several articles on asset protection and is an important contributor to the Asset Protection Handbook that I know many of you have studied and have right at your own homes. Bob will share his years of insights into how you can protect yourself from lawsuits and grow your wealth more quickly and securely. On today's Ultimate Asset Protection webinar, please have a notepad near you so you can write down the structure as Bob presents it. This structure is not presented on any other platform in the nation, and I challenge you to find another structure that is as simple, as inexpensive, and as safe. And I'm so excited now to present to you Bob Bluhm.
Well, thank you, Ashley. And it's good to be with everyone on the call. And we need to dive right in because we've got a tremendous amount of ground to cover. I hope you'll all take good notes because we have a short amount of time. Cherif does a marvelous job of teaching real estate investors how to make money in real estate. And I've worked with Cherif many years, and he is, as far as I'm concerned, the master. He's the real deal, really good at investing and helping investors as well. We call making money offense because, of course, you're trying to score. And a lot of people think that's exactly what I need. I need to make a lot more money because then all my problems are going to be over. And I think you're all smarter than that because you know that offense is a very important part of the game, but offense is only half the game. The other half of the game is defense. And that's exactly what I'm going to be talking to you during this webinar about is defense. So a word to the wise, you're going to have a defense every bit as good as your offense, or you do not win this game. You're just in the game and getting beat. So let's get started because some people really wonder, well, why do I need a defense? Who's coming after me? Well, I think that if we're even paying attention, we know that there's been an explosion of lawsuits in the last maybe 20, 30, 40 years. And many people ask me, Bob, why is this? What's going on in our country, in our legal system today? And one of the answers as to why we're seeing far more lawsuits today than ever before is this thing called the internet. As soon as Al Gore invented the internet, lawyers jumped all over it and figured out how to use it to sue people. So for instance, is anybody, you got to ask yourself, are lawsuits more common today than they were 40 years ago? And the answer is certainly yes. Are there more things you can be sued for today? And the answer is with every new law comes a whole new class of lawsuits. So yes. Are the damage awards bigger than ever? And the answer is yes. And then is this trend likely to continue? And the answer, of course, is yes. As many times as we'd like to stop it, turn it around, it seems to get worse and worse. And as I mentioned, one of the reasons is because of the internet. Has anybody seen this on the internet? It's a real website. And then, of course, there are many others. Here is the most sued profession in America, doctors, and the internet teaching people how to sue a doctor. Right behind that is landlords. So how to sue your landlord in small claims court. The internet helping people suing a landlord in 7 steps. And then one of my favorites is Sue Easy, take the power back. So here we have lawyers basically encouraging people to sue. One of the reasons for this explosion of lawsuits. Now, in addition, the internet has made it even easier for plaintiffs' lawyers to do their jobs. And here's what I mean. To understand what I'm about to say, we need to understand the incentives, the dynamics of a lawsuit. So when someone decides to sue, it's because they're injured in some way, they're hurt physically or financially, and they're upset and angry, and they go to a lawyer and they say, I want to sue that person, the SOB. And the lawyer says, okay, I'm going to take your case on a contingency fee basis, which basically means that the person suing, who's called the plaintiff, puts up no money, pays nothing at all. The lawyer puts up all the money, pays all the fees, all the court costs, and assuming they win, the lawyer will then take 30, 40, sometimes 50% of everything they collect. So the lawyer gets paid contingent on winning. So you think about this. For someone considering suing, they're going to do a cost-benefit analysis and say, well, what's the worst thing that can happen if I lose? And the answer is nothing. But what if I win? Wow. Could be a big payoff at the end of the day. There's no risk in this, so why not sue? It's the lawyer taking all the risk. So the dynamic is, sure, let's sue. All right, now you understand when you're the one sued, you will never get a lawyer to take your case on a contingency fee basis. When you're the defendant, the person sued, you will have to pay hundreds of dollars per hour to defend yourself. And so right from the get-go, the deck is stacked against you, the person being sued. All right? Now, having said that, the plaintiff's lawyer is very interested in making sure that they get a recovery because they're going to take 30 or 40% of what they win. So if they're thinking of suing you, what happens is the plaintiff's lawyer will hand your name to a legal assistant and say, go to the internet and do an asset search. Now, this kind of site didn't even exist maybe 20 years ago before the internet really took off, but there are hundreds of these sites now. And here is a typical assignment. It says this site provides detailed financial information to assist attorneys and clients in determining the economic viability of litigation, which means in plain English, how much can we take from you if we sue you? Now, it goes on to say, we identify your bank accounts, your brokerage accounts, real property, vehicles, watercraft, aircraft, business affiliations, and other valuable assets to satisfy judgments. So if you own it, we'll find it. There's always a digital trail these days. Now, once they can see you have something, they want to know, well, how much do I really invest in this case? How much time? What's really at stake? This next site will tell them every piece of real estate you own, when you bought it, and what you paid for it. In addition, they'll find all your buddies from jail, every place you ever lived, your social security information, your current address. And once they've got your current address, they'll go to a free website called Zillow.com and find the county appraised value of your home. Now, this happens to be a swank neighborhood on the West Coast, but they'll find a mid-priced house where you live just fine. Now, they don't really care what the county thinks your house is worth. What they're trying to get at is how much equity do you have in your home? And you wonder, well, why do they want to know how much equity I have in my home, in my investment real estate? And the answer is because the equity is exactly what they can take to satisfy a judgment. They can force a sale and take the equity. And that's what this next site will give them. It includes a real property equity assessment because this is all public record. Now, it's always been public record. What's changed is the internet. In the past, they had to go to this office, that county, the next state over. It took too much time and money and they didn't do it. But today, with just a few clicks of a mouse, they're going to know more about your finances than you do. So many people, when they realize that this is actually the process that takes place, end up feeling extremely vulnerable, and with very good reason. Now, there is good news, and it's this. There are simple and inexpensive things that everybody here can do to make that equity appear not to be there at all. And what that accomplishes is this. They're going to be spending about 30 seconds doing a quick scan of you online. And if you look broke, the calculation is, well, what's 30% of zero? Zero. There's nothing in it for me. And the plaintiff's lawyer finds somebody better to sue. The point is that you want to have assets, you want to have money, but when someone does an asset search on you, you want to look flat broke. So we'll talk about what we can do, those simple, very inexpensive things that we can do to look broke and essentially make the equity disappear. That is the key, because equity is what a plaintiff wants. And if there is no equity, then it's much less likely you'll be sued. Now, let's talk about where these lawsuits come from, because I know many people think, well, look, I've never been sued. I don't know anybody who's ever been sued. Well, first of all, that's wrong. You may have never been sued, but I know you know someone who's been sued, because think of this. This is a lawsuit. And it's one of the most common lawsuits where you can lose up to half or everything you own. And the kicker is you don't have to do anything wrong to get sued this way. It's called no-fault divorce. And in fact, I want to introduce that as a theme. You don't have to do anything wrong in America today to get sued. And I'll tell you why as we proceed. Another example of that issue is this. Let's say you have a business with one person working for you. Your employee injures someone. You now get sued for what your employee has done wrong. Another instance is this. Guest accidents in the home. You're a homeowner. Somebody gets injured on your property. Now you get sued. And that could even be someone who is trying to rob your home, gets injured on your property. And now they turn right around and sue you. There have been many, many cases involving that kind of issue. And so now you've been sued for something you didn't necessarily have anything to do with. Now, you may be thinking, well, that's okay because I have homeowners liability insurance to cover that kind of thing. And I certainly hope you have homeowners liability insurance. We should have that. But did you read the fine print in your policy? Because the fine print says the insurance company will pay only up to a cap called the coverage limit, which is typically $300,000 to $500,000. And that may sound like a lot of money, but Forbes magazine reported that in recent years, the average damage award in this country has tripled to $1.2 million. So let's assume someone gets hurt on your property. The jury returns an award for $1.2 million. Your insurance company pays the first $500,000. There's a big problem here. And you could be going broke even though you had insurance when juries add zeros to damage awards. Now, a fourth very big way that far too many people end up in a lawsuit is because we tend to own our assets in joint ownership. There are many forms of joint ownership, but the most common is joint tenancy. And then the very most common, if you live in one of the 11 community property states, is in fact community property. If you're simply married, you're generally in it. So there was nothing wrong with you owning your assets with your spouse or a parent, a child, a sibling, a friend.
There was nothing wrong with that until June 26, 1985, when the U.S. Supreme Court changed the law by ruling that if you have a joint owner who does something wrong, you can now lose every asset you own jointly with them, even though you did nothing wrong.
Many people unwittingly end up getting sued is because you may be doing business with a family member or a friend. And you may now have the most dangerous business structure you could ever have called a general partnership, which means you may now go broke for what your partner does wrong. And people often say, well, how did I get in a general partnership? I didn't sign anything. You don't have to sign anything. All you have to do is simply be in business with somebody else. And if you did not set up a corporation the way you knew you should, you are in a general partnership by default. Now, let me explain something. Real estate, as many of you know, if you're real estate investors, is a people business in which you partner frequently. We often need money partners. We need other people who are working with us. We often work in a team of people. And it can be very easily construed to be a partnership if you're not careful. So the way we avoid that, a very simple way to avoid that, is to merely set up a corporation business with someone else, split the profits with that person. Now, rather than being in a general partnership, you are in a corporation in which the two of you are shareholders or stockholders of the corporation. Now, let me contrast these different scenarios. If you're a partner in a partnership, you have unlimited personal liability for the debts of the business. You can go broke for what your partner does wrong. But if you are a shareholder in a corporation, now you have zero liability for the debts of the business. Very big difference. And so you always do business, if you're doing business with someone else, as a corporation. Now, another issue is this. People often say, well, what if I want to do business all by myself? Why would I need a corporation? Well, for many reasons, aside from the tax benefits, let me put it this way. You now have a liability if you're not doing business with a corporation. Put it this way. If you're doing business as a sole proprietor, which you would be doing if you're not a corporation, and that's your business, a sole proprietorship, something goes wrong and they sue the business, they're suing you, and they can now take everything you own. So we set up a corporation to do business, and we're going to be doing business all by ourselves. And now the business gets sued. They have to sue the corporation rather than you. And because they're suing the corporation, they cannot take your personal assets. So I hope if you're taking notes, you'll write down this very important rule, which is that corporations generally protect your personal assets. Again, corporations generally protect your personal assets. For those of you who already have a corporation or perhaps an LLC, which is a type of company, then I want to congratulate you because you're running a business the correct way as a business entity, a corporation, or a limited liability company. However, I want to point out that there are major loopholes in every single corporation. And if you do not close these loopholes, that'll be exactly where the plaintiff goes to sue you and take your money. Now, the first loophole is this. Let's assume you have a corporation. And something goes wrong. They sue the corporation, and the rule is they cannot generally take your personal assets. Okay, good. Here's the loophole. When they sue the corporation, they can take everything in the corporation because corporations protect your personal assets. They do not protect the business assets, or in other words, the assets owned by the corporation. They sue the corporation. That's exactly what they take is the corporate assets. So in order to protect those valuable corporate assets, we use a very particular structure to protect those business assets. So even if they sue your corporation, they get nothing, and you have protected all of your business assets. Now, a second loophole is this. Let's assume you have a corporation, and that's good, once again, but that's all you have, the only thing you knew to do. Something goes wrong, they sue your corporation, and of course the rule is they cannot generally take your personal assets. But many of you I know have already spotted a wiggle word, generally, which signals an exception, and here it is. Many of you have heard the phrase pierce the corporate veil. Now, what that simply means is this. Let's assume that you set up a corporation, but then many small business people, you're busy in the business, you forget all about the corporation, you just run your business any way you want to, and something goes wrong, they sue the corporation, and the rule is they cannot generally take your personal assets. But here's the exception. They will try to pierce the corporate veil. Now, what does that mean? It means that, yes, they can take the business assets and you'd be out of business if they won the lawsuit, but then they often want to take your personal assets too. And of course, your lawyer would say, well, you can't get them. They're protected by his corporation, his or her corporation. But the plaintiff's lawyer will say, watch me. And they will now demand from you every document relating to your corporation. They'll say, I want to see your minutes, I want to see your annual meetings, I want to see your bylaws, I want to see your director's resolutions, I want to see your waivers of notice, I want to see this, I want to see that. And if you didn't dot every I and cross every T, they're going to walk into court and say, Your Honor, so-and-so ignored their corporation all these years, so why shouldn't I? And the judge is going to rule, you never treated that corporation like a separate legal entity. I've got a rule. You have a sham corporation. Plaintiff, go ahead and take their personal assets. And you are now wiped out. Lost your business assets and personal assets too. It's tragic. I've seen it happen far too many times. So we have got to be able to protect those valuable personal assets with the most powerful technique there is. So even if they pierce the corporate veil, they will get nothing and you are protected all of your personal assets. Now, a third quick loophole for every corporation is this. When you have a company, you have to have somebody running it. That'll be a president, a vice president, a secretary, a treasurer. These people are called officers of the company. And officers and directors of corporations are personally liable for what the company may do wrong. That means they can sue you personally for what the company does wrong and now take your personal assets. Because of this, it is imperative that we protect these valuable personal assets, again, with this very important legal strategy. So even if they sue you as an officer, they will get nothing and you have protected all of your personal assets. All right, now a seventh way people sue, or get sued rather, is because you're not officially an officer of the company, but you look like an officer of the company. By that I mean, in real life, busy people tend to turn to their spouses and say, honey, I'm so busy with the business, would you mind just keeping the books? And then sooner or later, you know that spouse will be signing the checks to the banks and this and that. And now to the outside world, that spouse looks just like the secretary treasurer of the company because they're functioning as the secretary treasurer. The rule in court is very simple. If you look like an officer or you smell like an officer, that's close enough, you're an officer. And eighth way, almost everybody on this call is wide open to being sued is because you are the owner of an asset, and that alone can be unbelievably dangerous. Now, let me illustrate. Assume you're the parent of a teenage driver, and your teenager cannot own anything legally until they're a certain age, and so the car they begin driving is titled typically in your name. Son or daughter gets into an accident, and the person who gets sued is you. And you might be thinking, well, why would I get sued? I wasn't driving, I wasn't in the car, I didn't do anything wrong. Well, you get sued because you're the owner of the car. And the law assumes if you own the car, you control the keys. And so since you allowed a negligent driver to drive your car, the liable party is you. So think hard about what titles you've got your name on. Ownership brings liability. And typically people have their name on their vehicles, on their homes, on their bank accounts, their savings, their investment accounts, their stocks and mutual funds, and they have it on their, if they're really doing it badly, on their investment real estate. And for every one of those assets with your name on the title, when something goes wrong with that asset, the liable party is you. So We have got to be able to protect these assets, even if we have our name on them, on the titles. So I'll share that with you in just a little bit. Now, people will look at this and say, you know, we have way more liability today than we ever had before, and I think we need to beef up our defense. We're going to buy some more liability insurance. Now, do not misunderstand. Everyone who owns important assets should have insurance. I have it. You have it. It is a very good, important, imperative first line of defense. But if all you can think of for a defense is insurance, you have a problem. Because while it's part of your defense, think of this. If all you do is buy more insurance, buy even more insurance, do you think all this insurance is going to deflect lawsuits away from you, or more likely attract lawsuits? And folks, people often say, okay, well, what do I do? And the answer is have a real backup plan. And people say, well, why do I need that? I've got insurance. Well, has anybody ever heard of an insurance company ever denying a claim? I mean, someone once said that insurance is a little bit like a hospital gown. You only think you're covered. So if the insurance is not there for you for any reason and you do not have a backup plan, how will you survive what can be a multi-million-dollar loss? Well, we could go on with this forever, but I'm sure you've got the idea. Not one of the people on this list had done anything wrong. Every one of them got sued. And folks, it is because of a legal doctrine in our country that I completely disagree with, but I'm in the minority. It is the law, and it's called vicarious liability, which is the legal that basically says you can be sued for what somebody else does wrong. And I've just illustrated that many times. In other words, you can be sued for what your employee does, your spouse does wrong, be sued for what an employee does wrong. You can be sued for what an intruder on your property does wrong. Number 4, you can be sued for what a joint owner does wrong. You can be sued for what another partner does wrong. You can be sued for what another officer does wrong. You can be sued for what your kid does wrong. In other words, the law today says you can be sued for what someone else does wrong, and that's the law in America today. Now, the problem is obvious. You and I do not control these other people's actions. And if we don't control their actions, but we can be sued for their actions, then how in the world are we supposed to control our liability today and protect what we've worked so hard? And the way we protect our clients and keep them off of a list like this is what I will introduce to you next. Because remember that equity in real estate is what a plaintiff wants. And the good news is, if you remove the equity, then you become like a piñata without the candy. There's nothing there for the plaintiff to take. And so let's talk about lawsuit protection and one of the most innovative, simple, and least expensive asset protection techniques that I have ever encountered. And it's this. It's a very familiar concept. Let's assume we have a home that we have bought. It's our pride and joy, perhaps our first house, and it has a fair market value of $100,000. Well, the bank, of course, you have a mortgage with the bank, let's say, for $100,000. There is no equity in that property, and we all typically joke, yeah, I don't own the house, the bank owns the house. And that's basically true because we don't have any equity or ownership stake in the house. There is no equity because the lien has claimed any equity in the property, the lien that the bank holds. So let's do it in another way, drawing another type of picture. Let's say the bank has that lien or mortgage on the property for $100,000. There's simply no equity because it's worth $100,000 and there's nothing there. Well, if we substitute this bank for a new LLC, and let's say we actually have paid off the house now, we really have $100,000 of equity in the property. Well, what we want to do is this. We want to pledge the equity to capitalize the LLC. That means it's a promise to pay the LLC $100,000.
It's a promissory note. This way, the LLC has a lien against the asset for $100,000, and the result is there is no equity.
And when a plaintiff who is doing an asset search now, as you remember that computerized asset search I showed you earlier on, they encounter this kind of situation, it appears there is absolutely no equity in the property, and that their calculation is there's nothing in this suit for me. 30% of zero is still zero. All right? So what happens if we have multiple assets, as most of us do? We have real estate, we have our personal home, we have business assets, we own personal property, and we want to protect these assets. Well, we just use the same technique applied to these different assets. In other words, we pledge the equity in these assets to capitalize the LLC. Then we establish a promissory note between the LLC and us, and then the LLC files liens against the assets. And these are recorded liens against the assets so that it's noticed to all the world that the equity has a lien against it. And the result is no equity. It's a wonderful, wonderful, simple approach. Now, remember, they're going to be doing asset searches on you when they want to sue, when they're contemplating suing. Here's the good news. When they do that asset search now, they come up with no equity in the assets. And again, if there's no equity, then there is nothing to take. No equity means that you are much, much less likely to be sued. I think you can all see exactly why. You become that piñata without the candy. There's nothing there. All right? So, this is a great technique. People might say, yeah, but what if they sue the LLC or me? What if they sue me? Because I own the LLC. Well, here's the good news. If they sue you, can they take your assets? Can they take anything from you? And the answer is no. Now, you might say, well, why is that? I don't get it. Why can't they take anything from you? And it's because of the fact that we now have something called a limited liability company, which is a unique tool in the law. Now, I know most of you have heard of LLCs. They are badly understood. They are widely misunderstood. The real potential of LLCs is not even begun to be realized. Let me tell you why this is such an important tool and the particular type of LLC we want to use, because not all LLCs are created equal. The first LLC was created in our country in 1977 in the state of Wyoming. It's found in Wyoming statutory law. And no other state even adopted LLCs for years because no one knew how they were going to be taxed. And then so finally that issue was resolved. And then slowly states began to adopt LLCs. They kind of moved from the west to the east. And some states on the East Coast have only had LLCs in the books for maybe 15 years. So this is a relatively new tool, which probably leads to the fact that few people really understand it, even though they've heard of it. Wyoming, because it was the very first state to create an LLC, has been the leader in LLC law ever since. So it is the one state with the most experience with LLCs. It is a state that has been very, very protective of LLCs in its laws. Now, here's what we're going to do. We're going to put the promissory note evidencing the pledge of the equity into the LLC. This is considered to be commercial paper. In other words, you could sell the note. So it's an asset, even though it's an intangible asset. So what gives the LLC its particular unique protection is something called a charging order. So in other words, when they sue the LLC, when they sue you as the owner of the LLC, they do not get the promissory note. They do not, in other words, step into the position of the LLC and become the note holder. Instead, when they sue you as a member of the LLC, what they get is a charging order. This is considered to be the only remedy they will get when we use a Wyoming LLC. And a charging order is the last thing that the plaintiff wants, because it gives the plaintiff 3 migraine headaches. Headache number 1 is the right to seize a certain percentage of your assets from your limited liability company. And the exact percentage they get to seize every time by law is 0. They cannot seize, attach, or levy upon a single asset in the LLC, and that is the law of the land if you use a properly structured LLC set up in the proper state, and that would indeed be Wyoming. Now, the second thing to get is not your assets, but they have the right to take the income that you distribute from the LLC. Now, we have in our operating agreement, which is the guts of the LLC, the key document for the LLC, sometimes called the company agreement in different states, very important key language, which indicates that if you have been sued, you as the manager of the LLC have no obligation to make any distribution whatsoever. And so what they would receive is 0 income, because they can only receive income that is actually distributed from the LLC. And of course, if there's a plaintiff or a judgment creditor waiting to receive income, you're not going to distribute any income. Now, that means they've got no assets and they've got no income, and they're getting very discouraged. But the third thing they get with a charging order is the best of all. And it's this.
In the year 1977, the IRS issued one of the most famous revenue rulings of all time. It's known as Revenue Ruling 77-137, and this is the tax law of the United States. And basically, the IRS says here, we don't care that the winner of the lawsuit got a judgment against you for, let's say, $2 million. Well, we don't care. Even though the winner of the lawsuit got nothing from you, no assets, no income, the winner of the lawsuit still must pay income taxes on the $2 million you never gave them. And folks, that is exactly why so many people have said the ultimate lawsuit protection entity is a charging order protected entity. And that is a Wyoming LLC. There are just a few other states, a handful, very, very few other states that have any kind of protection like this.
So why do we use the limited liability company as a lawsuit protection tool? And why does it hold this very important promissory note? Because when they sue you as a member or an owner of the LLC, they get nothing. You are protected by the charging order. That is what makes that limited liability company in Wyoming so very, very unique. Now, there are other states that have LLCs that have charging orders, but Wyoming is by far, once again, the leader in LLC law, and it has created one of the very strongest charging orders there. Do not assume that simply setting up an LLC in any state is going to give you that same level of protection. It will not. All right? Those charging orders vary in strength dramatically from one state to the next, and Wyoming is the state that has one of the very strongest charging orders in the country. Now, you could have a structure that can be quite complicated. And I have set up structures like this for people over the years, and it is appropriate in certain circumstances. But I have to tell you, A structure like this is complex, as you can see. It is expensive to set up because you have a lot of different entities to set up. There's an expense to that. There are a lot of filing fees involved in every state. There are administrative burdens, because now you have to make sure you've dotted this I, crossed that T. You've got to make sure these entities all relate to each other in a certain way, and it becomes expensive, it becomes complex and difficult to operate. And that's not to say that in a certain circumstance, this wouldn't be the appropriate thing to do. It certainly may be. But if there's an easier way to do it that is less complex, less expensive, and accomplishes the same thing, then wouldn't we want to do that? And in fact, this can be the structure. It's a Wyoming LLC, properly drafted with a properly drafted operating agreement. And that becomes very simple, easy to operate, and inexpensive when that LLC, now having been properly formed, holds that promissory note, which strips the equity essentially from your assets. It is one of the simplest, one of the easiest to operate and least expensive structures that accomplishes asset protection. So we have a number of steps that we would take in order to set up a structure like this. And the first is that the LLC is set up in Wyoming, which is the first state to create an LLC, and as I've mentioned a couple of times, a leader in limited liability company law. Second step is that the LLC operating agreement must have certain key words, providing a business reason to exist beyond simply asset protection. I might also add that most operating agreements I have reviewed over the years are very, very badly written. They undercut the charging order protections. They are written without any kind of understanding of what the limited liability company can do in terms of asset protection very often. Third is there's only one interest payment made, and it's an interest-only payment per year under the promissory note. So once again, this is not a weekly, monthly, quarterly kind of payment that you've got to remember. You put it on the calendar once a year, the note gets paid on an interest-only payment. Fourth, you have full control to cancel, write off, or subordinate the note at any time. Because you are a signatory to the note, and you also control the LLC. So you're able to cancel the note if you need to, write off the note, subordinate the note if you're going to refinance the property. A fifth good point here is that there are no ongoing legal fees to maintain this structure. It's once it's done and becomes a much, much simpler approach. So you might be thinking, yeah, but what if I've already been sued? And the short answer is, or rather the question that I get all the time is this: if I've already been sued, isn't it too late for me to protect myself? And what people are referring to is something called a fraudulent conveyance. Let me take just a minute to explain this concept. The short answer is yes, you're too late. There's another answer that'll say, yes, you're too late, but we can still protect. And I'll explain that in just a minute. The general concept is this: if you have a known plaintiff, in other words, you're aware that someone's suing you, or you have a readily identifiable plaintiff. In other words, you just got in a car wreck, the other driver was very badly hurt, you know they're going to sue, that's the same thing. In other words, you know you'll be the target of a lawsuit, it's just a matter of time. In this instance, if that's the case, if you tried to protect your assets, it would be considered a fraudulent conveyance. In other words, we're not talking about criminal fraud. That's a little too strong a word when we say fraudulent. What it means is we're trying to take these assets out of the reach of a bona fide creditor who has the right to get those assets. Can't do that. It is prohibited by law, all right? Because we have as a public policy in this country that an injured party has the right to recover. And it would be wrong, and I think not only ethically wrong, morally wrong, it would simply be wrong in every sense to try to deprive that person from becoming whole by depriving them of a recovery. All right, now that's kind of strong medicine. If you're the one sued, you're thinking, yeah, but those are my assets. I don't want them to take my assets. Of course you don't want them to take your assets, but this structure needs to generally be set up before any kind of a lawsuit arises. Now, you may say, yeah, but now that's not me. I've already been sued. How do I protect myself? So let me give you a scenario. The best kind of approach is this. There's no lawsuit on the horizon. You have not been sued. Nobody's threatening to sue you. We get this structure in place. Now you're well protected, all right? However, let's say that we don't have this structure in place and someone is suing you in your business. They're suing your corporation and they want your business assets. Okay, that's what's at risk. Now notice, we have real estate over here that's not involved in the lawsuit. We have our personal residence that's not involved in the lawsuit. There you have personal property that's not involved in the lawsuit. Let me give you another instance. Let's say they're suing you for $150,000 and you have roughly $150,000 of business assets or equity in your business assets. All right? Here's what we can do. We can protect everything but the target of the lawsuit. To say it another way, if you were sued for $150,000 and you had a net worth of $1 million, we could protect the other $850,000, which is not the subject of the lawsuit, but we could not protect the $150,000 that is in controversy. Now, they may win, and if they win, then they're entitled to the $150,000 that they're after. So we do not place the lien on the $150,000 worth of assets that is the subject of the suit. But here's the problem. If you do nothing, in other words, you go back to a situation like this and we're frozen in our tracks because we have been sued, what happens if there is a second lawsuit with an unrelated plaintiff that arises? Now you had the opportunity to protect other assets, which you didn't do, which are now vulnerable to that second lawsuit, in addition to the assets being vulnerable to the first lawsuit. So instead, we want to get the other assets protected, not from the first lawsuit, because we cannot protect from that. But we do want to protect from potential subsequent lawsuits. And the mere fact is this: if you've already been sued or threatened to be sued, you know how real it is. It's not a theoretical possibility. It's a real deal. And you know that lightning can indeed strike twice in the same place. So you bet we want to get those assets protected. And the good news is you can protect the assets that are unrelated and not in controversy, unrelated to the suit. All right? So how do we go forward if this is the case? Well, the first thing we want to do is to provide you with that customized Wyoming limited liability company. Very important to do. It needs to be, again, in the right state and drafted in a very, very careful and particular way. Second, we would provide that operating agreement with all the key words, and that's exactly what I was just referring to. That those first two steps have a $3,300 value because that has got to be done very, very carefully. Second of all, in other words, this is not just some cookie cutter mill where we're going to do this. It is a very, very careful process. Now, third, we want to provide a customized promissory note to encumber the equity. Then fourth, and by the way, you can see that because it's a customized note, that will be a $1,500 value. We then will provide you with the limited liability company ownership certificate. This is very important because as you need to do business with the LLC, you need to be able to prove that you are indeed the owner of the LLC. That is a simple $500 value. Fifth step is we will provide a lien for filing. This is critical. This will be notice to all the world that the property is indeed encumbered. And that is the ultimate step that removes the appearance of equity from the property. That is a $1,250 value. And then we will provide registered agent service for one particular year. Your very first year, that's a $450 value. And then a year of hotline support, which is critical because as you have any questions or have additional assets to protect, we will be there to answer your questions. That's a $2,500 value. So to review, many of you know that this is what you need to do. And if that's the case, there's nothing more to talk about. I'd encourage you to just go ahead and call in or go to the website and order your package. Now, to review very quickly, the steps are that we're going to provide the Custom Wyoming Limited Liability Company and the operating agreement with all the key words, a $3,300 value. We'll provide the custom promissory note to encumber the property, $1,500 value. We'll provide the Limited Liability Company ownership certificates for $500 value. We'll provide the lien for filing. It's a $1,250 value, and provide registered agent service for a year, a $450 value. And then finally, to provide 1 year of hotline support, which is a $2,500 value. That is a $9,500 value that we've just described. Now, you could have easily paid much more than $9,500 just for the setup of this structure, and then have ongoing annual renewal fees, filing fees, annual report fees, registered agent fees, all over again. And this becomes very expensive to maintain and operate. On the other hand, you could use this approach. And because that we have been able to achieve economies of scale over the years, we can discount this, and no longer is it $9,500, even though it's the value. We can offer this for $4,995 at a discounted price. So it becomes a tremendous value. All right, now, for those of you who are interested in this, we're going to have a wonderful bonus for you, and that'll be a living trust that is included with your purchase for $99. That is really a $1,200 value, and I'll be honest with you, I've seen a lot of living trusts being sold for $5,000 and between $5,000 and $10,000. But why can we do this for $99? Because it'll be a living trust that avoids probate. That's the purpose of the trust. The trust, if you do not have a living trust and only have a will, you'll go through probate, which is a public process, which is a lengthy process and also an expensive process. So with a living trust, you avoid probate altogether, you protect the privacy of the people you leave behind, and you protect the assets that you're passing on from prying eyes. So a living trust is really a recommended tool, and it's a tremendous opportunity to get one for a very, very low price. Now, I have 6 slots available over the next couple of days. I'm very, very busy. I only have those 6 slots, and I'm more than happy to, if you have been sued, to discuss your particular legal situation and what might be an appropriate way to help you. Once again, I'm going to make this clear. I really only have those 6 slots. So by all means, call now if you're interested in that, and reserve one of those 6 slots. So with offense and defense together, I want you to realize that when you do what Cherif teaches you to do on the real estate side, the money-making side, and then you couple that with the ultimate asset protection strategy that we've just described, now you have offense and defense together, and that means you have more money. It means you have financial security, and it means you finally have peace of mind. And you've got to ask yourself, what in the world is that worth to you? And for most people, they tell me it's priceless. Now, one person summed it all up by simply saying this: the most important thing is knowing that my wife and kids are protected forever. And folks, I want to thank you, but I'd encourage you to take action now. Get your asset protection plan in place. Call the office and or get on the website. I want to thank you for your kind attention on this webinar, and we'll be talking.